24R00553OM, City of Royal Oak versus Jonathan McCall.
Ryan Clues on behalf of the City of Royal Oak.
Oh, you're muted, Mr. Angot.
Or get it right. John Angot appearing on behalf of Mr. McCall as co-counsel.
Melissa Crosscroft also on behalf of Mr. McCall, Your Honor.
Mr. McCall, your first and last name?
Jonathan McCall.
All right, this is the date and time set for a pre-trial here that the court had set late last week. I'd appreciate everybody getting logged in here on short notice. Mr. McCall is appearing by audio only, having some issues with his connection to get video and audio going. Does anybody have any objection to Mr. McCall continuing with this audio only phone call?
No, Your Honor.
Well, Your Honor.
Not from me, Judge, but I guess I would ask the court to inquire of Mr. McCall, and I know you probably were going to.
Mr. McCall, are you okay proceeding with just the audio connection here today, given the difficulties with your audio video connection?
I'd rather do everything in person, but my opinions don't seem to matter to the court. So it's whatever's it's just whatever you guys decide, apparently.
Well, okay. Actually, I didn't know that you wanted that request. I'd certainly proceed with in-person hearings in the future, given that request. I didn't realize that you had that desire. I thought that you wanted to continue with Zoom, but I'll keep that in mind moving forward here. So this is the date set for a pretrial. Couple of things. The court was in receipt of a letter from a Todd Nadeau, a clinical director at Performance Psychology. Defense counsel, have you seen and reviewed that letter?
Yes, Your Honor.
Yes, Your Honor.
And I asked my staff to forward that to Mr. Klusny. Mr. Klusny, did you get a chance to look at that?
Yeah, I did get it, I believe late this morning, Judge.
Okay, so it clearly indicates some ongoing mental health treatment that Mr. McCall is undergoing. I won't go into the specifics, but just to say that it does put into writing the statements and representations that Mr. McCall made at the last hearing. So I've reviewed that. The court brought everybody in today, though, because after our hearing late last week, the court had a chance to kind of further consider the arguments and the statements that Mr. McCall had made on the record. That prompted some concern about Mr. McCall's ability to understand the nature and object of the proceedings that are going on against him here in this case, and his ability to assist in his defense in a rational manner. Because of those concerns, the court did look into some of the past correspondence that Mr. McCall had sent the court over these many months while this case has been pending. And that brought up further concerns to those 2 points that I had just stated. Mr. McCall has continually seemed to talk about some coordination efforts between different government agencies here at the city, the court, the police department. Seems to be linking some of the past things that have occurred with Mr. McCall and those agencies into this proceeding. Things that just, again, concern the court enough to where I think at this point it is appropriate that the court refer a competency evaluation here for Mr. McCall. So that's what the court is going to do on its own motion.
May I speak on my behalf, sir, Your Honor?
I'll let you address the court here in a second, Mr. McCall. I just want to finish.
Okay, yeah. I just know
I need to do.
But I'm sorry.
So, you know, I know that this comes with its own response, I'm sure, from Mr. McCall. I just want to reiterate, I don't think the court has much of a choice here. Looking at the court rule, it appears to be mandatory once these concerns pop up in the court's mind. The court needs to have one of these evaluations done. And so that's what the court is going to order. And I'm going to ask Mr. Klusny to prepare that order and submit it to the court so that I can sign it and have that start going. Because of that, I think it does a little bit to our timeline. So last time we were here together, we set a jury trial in January. I'd still like to keep that January trial, but I do acknowledge that it's probably a bit hopeful to think that we'll have that report by then. But what I'll do is just set a pre-trial in a week or two ahead of that trial date, and then we can come together and hopefully have a response from the forensic center. But if not, then we can make some adjustments at that time. So I put that on the record. I told Mr. McCall I'd give him a chance. Mr. McCall, you still have the absolute right to remain silent throughout all these proceedings. You have two attorneys here that can speak on your behalf. But it sounded like you want to say something, so I'll just leave it at that and allow you to say something if you wanted to. But I don't know if counsel wants to say something first or not.
Yeah, if my counsel wants to speak first, they can. I don't care. I just think this is unacceptable.
All right. It looks like they're go ahead, Ms. Kowalkowski, about to say.
Your Honor, the court has ordered what it has ordered, and so that is what it is. I will say I think that January trial date will likely have to be moved. I think on someone who is out of custody, I mean, it's taken about 3-4 months on people who are in custody. The only thing is, Mr. Kaluzny, when you do the order, if you could just kind of keep track of it at the forensic center for us, because sometimes what happens is they'll notify the client and not us of when they need to report. And sometimes it's the other way around where they'll notify either Mr. Rangout or me and not the client. So if you could just kind of keep on track of where we might be there. Sometimes they're more likely to answer the prosecutor's calls about that than ours.
So let me ask you a question now.
Go ahead, Mr. McCall.
So you're trying to take me into custody for stating the facts of what happened inside of the hospital.
Mr. McCall, you are not going
to take me into
nothing is
okay. Well, take me into a competency exam. Extend this even further. When the thing is that if I am incompetent, it's because of racism and discrimination. If you have a moment, or if you will, if there is a sign of me acting maybe out of myself, it's because of racism, discrimination, and being assaulted. It's offensive. I don't feel I need to go inside a center. I don't feel I need to even sit down and speak with anyone regarding this. These things are established facts. May I finish, please, Judge, Your Honor? These things are established facts. What I've stated, I'm not going to sit and lie to you. I'm not going to sit and pull something out of left field, right field, ball it all up and say, hey, that looks good, and throw it to the court. What I've spoken is true. And to go through this, to have my word to be, shot down when I've been a law-abiding citizen, I've had no issues with the law. I'm 47 years old. Haven't had any issues with the law outside of them placing their hands on me when they shouldn't have. I haven't had any issues with any people outside of them placing their hands on me when they shouldn't have. I'm not out beating anybody up. I was a CPL holder, a lawful gun owner, and all of these things are being made to look a certain way so it looks good for one side or one group, and we know what side and what group that is, and to make it look bad on me. If this is what's going to go on, I'll just excuse myself from this proceeding and go ahead and, because I am with the, I'll excuse myself from this one, and then I'll speak with the Attorney General for the state of Michigan, go back to Washington, speak to the Attorney General, speak with the Secret Service, and also continue on with the Department of Justice. I didn't have to say that in this hearing in front of everyone, because I do not want everyone to know that there is a pending case with the Department of Justice or the Attorney General once I complete everything with the Michigan State Attorney General. I did not want to go ahead and do that because that would have possibly interfered with the Department of Justice interview. So everybody knows everything now. I'm not bluffing. I'm not making anything up. I'm upset because, again, racism, discrimination. I could go see Dr. Todd, Dr. Phil, Dr. Nandi. It doesn't matter. I could go see them all. There is no cure for racism and discrimination or perception or for someone who perceives they're being treated in that manner. And I know it's greater than me being perceived to be treated in that manner. As I'm 47 years old, I've had an experience with it over 45 plus years. All right, I learned certain words in kindergarten and in elementary and preschool that most kids today don't learn until they're much older. And it wasn't from my family.
Mr. McCall,
so
let's not end with this, Mr. McCall.
Here's the thing, Judge. Judge, here's the thing. I'm not a bad guy, and I'm not the bad guy in this. So I want a competency exam on every police officer that sat there and lied and said that I've threatened to kill 3 police officers, which kind of front-loaded this thing to get another judge to say, oh, we need to take away his rifles. Oh, we need to do this so we can gain entrance into the home, which they were already going in and going through the thing. So the only entities that were involved with this that I've stated from the beginning, Oakland County Sheriff, Royal Oaks Police Department, and you can also include the City of Detroit and also the Beaumont Hospital staff. That's the only one, which are some of the City of Detroit police officers. But that's the only people I've said. I'm not reaching out of left field. I find it offensive. I find it unacceptable. I find it, it's egregious. It's disgusting that I've got to go through this. Hey, the sky's blue. Well, we don't know. I think you need a competency exam. The sky's blue and has white clouds. Well, I don't know. We need to look at this. The sky's blue. Okay, it's storming. The sky's green. The sky's gray. Oh, we don't know. We don't think so. You're not going to take my word for anything, but you're going to take the word of those lying peace officers.
Yeah.
You guys take that word. Hold on, sir. Please hold on.
I'm going to give you another couple minutes here, Mr. McCoy, but
that's fine. I'll wrap it up quickly, sir. I'll wrap it up quickly. But like I said, you take the words of these officers, that attorney who doesn't know anything regarding me or regarding this situation or regarding this case. No one has looked at the facts of the statements that I've made. No one looked at the letter from CPS. No one looked at the investigation from CPS. No one looked at the investigation or the letter that my wife wrote that I had. People wrote letters stating of what happened that night. I asked a white woman to leave my house over 10 times. If you don't leave, please just step outside to calm everything down. But please just step outside. And here I am, 8 months later. I didn't put my hands on anybody, didn't spit, kick, punch, intimidate. I didn't do anything. And I'm sitting here going through this. Oh, we think you need a competency exam now. So what's that going to do? That's going to take the stuff you guys played your officers' lives and put stuff out there to the newspapers and all these groups, armed standoff. Well, Mr. McCall didn't have a gun in his hand. Barricaded gunman. Mr. McCall didn't barricade himself in that house. I'm not afraid of now one of you. I went outside and talked to the man. I talked to the police. I talked to your officers. The police officer, I believe it was Kaufman, or his last name starts with a K, the one that tried to break down my door unlawfully. That one I did. I told him to get the heck off my property because he tried to break my door down with no provocation. There was no lawful purpose for him to be there. Oakland County Sheriff, same thing. I spoke to him. He said there's no lawful purpose. I said I agree. So go ahead and you guys go grab something to eat and get up out of here.
Right,
like all of this is
its ruling on this issue. It's really not about the facts and circumstances of the case. It's about the concerns that I just went over on the record with regards to the communications that you've offered.
Everything
on the record.
You guys don't understand English. You don't understand English. I sent it in Arabic. You don't understand English. I sent it in Espanol, in Spanish. I'm telling you the truth. If you don't understand English, I can send it in Ukraine. I can send it in Russian. I can send it in multiple languages.
All right.
If you guys aren't going to understand English and aren't going to listen, then I will, like I said, I will hop on a flight. I will go to Washington. I'll get a court order from Washington. I'll get a court order from the Department of Justice and let them deal with you guys in that city with your issues and not mine. We'll have a competency exam on all of you, and we'll go from there.
All right, we're all set for today.
I'm not playing with any of you. Judge, I have respect for you, Judge. Judge, I have respect for you, sir. I'm not playing with any of you. I'm going to let you know that now. This is tyranny and oppression, and if that's the route we're going to go, the Constitution speaks in a language I love to speak in. If you read the letter about who and what I did and who I was, that letter will let you know if you read between the lines. I love it.
All right, Mr. McCall, if you just let Mr. Angat address the court here. Go ahead, Mr. Angat.
Thank you, Your Honor. Judge, just for clarity, may we have both the court rule and the statute to which the court is relying, or upon which the court is relying?
Yes.
And I believe it's MCR 6.125 and MCL 330.2020 at sec. The statute itself covering the reasons why the court may on its own require this type of competency examination. It seems to be a two-pronged test. One being that the defendant is determined incompetent to stand trial only if he is, one, incapable because of his mental condition of understanding the nature and object of the proceedings. Judge, I would argue, and I think Ms. Krauskopf would agree, Mr. McCall has a full understanding of the nature and objects of the proceedings against him, or the other prong of assisting in his defense in a rational manner. Just so the record's clear, Judge, we have spent, I will say, at least point hours with Mr. McCall, both live, in person, on Zoom, through various written communications, and I do not believe that he falls into either of those prongs. I believe he is absolutely understanding the nature and object of the proceedings, and that he is able to assist in his defense in a rational manner. I just want to make that record clear, so we do have a record of our position.
Mr. Angot cited the appropriate court rule. I was addressing as terms of statutory authority that the court has. It's 330.2024, which indicates that the issue of competence to stand trial may be raised by defense court or prosecution. The court here in this case has raised the issue of competence on its own motion. Neither defense nor prosecutor has made that motion, and obviously Mr. Angot here arguing against the court doing what it has done today. But I think Mr. Angot does also cite the appropriate statute with regards to the two-prong test here for the court to consider. And the court made its record. That was the start of the hearing. I talked about the specifics. Has nothing to do with the facts and circumstances of the case, because as of yet, we haven't gotten to that point. It's only based upon the communications that I've seen here in court and the written communications sent in by Mr. McCall that the court's making this determination here today. So that's going to wrap it up for today. And then we'll get notice of our next dates out. Mr. McClusney is going to send in that order for the court to sign.
Judge, would you consider removing the tether based upon the correspondence you received from Mr. Nadeau?
Do the people have a position?
Judge, I mean, obviously I looked at the letter briefly. To me, it doesn't provide any specifics. It's just broad statements. There's nothing specific as to what exactly is going on and how often. And that was my issue with the letter.
Right. I understand the issue with the letter, but do you have a position with regards to the tether requirement?
Judge, I think part of the issue is understanding what the treatment currently is and what's happening, and I still don't really fully understand that. And based on that, I don't think anything should be changed.
The only thing I would, if I may, Your Honor, the only thing I would add is that both the May letter and this November letter, almost 6 months apart, claim from Mr. Nadeau, the therapist, that Mr. McCall is not a threat to himself or anyone else.
So here's the court's reading on this. And I agree with Mr. Angot. The letter from Mr. Nadeau does indicate that Mr. McCall is neither a threat to himself or others. There's also been this. The tether dates back to March 26th. Mr. McCall has not had any violations of the tether provisions for all of that period of time. The concerns that the court brought up here today have been present throughout, because in part the court based its ruling on communications that Mr. McCall has sent throughout that period of time. Mr. McCall is apparently treating with Mr. Nadeau in addition to others. I don't see a basis right now to continue on with the tether. So I'm going to amend the bond conditions to remove the tether. However, I'm going to alter some of the other specifics of the conditions of bond. So in lieu of the tether, I'm ordering weekly phone check-ins with pretrial services. I'd like also monthly updates of ongoing mental health treatment that Mr. McCall is engaged in, both with Mr. Nadeau And he's mentioned 2 other doctors now to this court on 2 separate occasions. So I'd like continuing updates from those additional doctors. If he's treating with them, they should provide updates. All other conditions will continue, which includes the no contact provisions. And I should also state, he's mentioned other proceedings, other ongoing court issues. If there is any other court orders out there, this court amending its bond conditions has no impact on any other judicial order, any other court's order, which may be in place. So those things, if there's another court that's ordering a tether, then my removal of the tether provision has no impact on that.
Am I allowed to go hunt? Am I allowed to go hunting to provide for myself at this point, because I'm being taxed on everything, Judge Your Honor. Sorry to cut you off. Am I allowed to go hunt and provide for myself, food for myself? Or is the court going to provide lunch stipends?
No,
Dinner stipends?
I'm not doing anything with the condition that you not purchase or possess any weapons or firearms. That's staying in place.
So that's to back things up. That's probably the reasoning for all of this. Like when the police officer was following me in the sporting goods warehouse and also Dunham's, and I have video of that I sent over to my attorney. But that's probably why he was doing that.
Mr. McCall.
Joseph Kutznick, Officer Kutznick, the one that looks like Caillou, the bald head guy. That's why he was following me around, and he was the one inside of my house with my wife. Is that why? Is that?
I muted Mr. McCall because he will not relent when the court is trying to explain its ruling after he brings up questions. The provision or the prohibition of purchase, possess firearms dates back to the nature of this particular charge. It has absolutely nothing to do with any of the other issues that Mr. McCall brought up. So that's the court's current amendment to the bond. We're all set for today, okay? We're off the record on this case. Take care.